All right, great to see you. We'll jump into Gifford chapter 5 and 6 in this session. We're talking about information gathering and initial proposals. I want to take a moment out here to just remind everybody that while academically we're breaking everything down into these nice, neat little segments, and we have to in order to study them and think about them. But as a practical matter, this stuff happens all and gets all jumbled up, and you're making an initial proposal. That's kind of a discrete thing very often, yes. And so that does somebody's got to start the process, and so that does lend itself to being a sort of a discrete event. But once the race is on, so to speak, once the horses have left the gate, I live in Louisville, Kentucky, so it's a big deal around here, horse racing. Once the horses have started and left the gate, it gets to be a big mishmash of horses running down the track, and you know, where does the initial proposal end, and the information gathering begin, and where does the you know uh, exchange back and forth, and where does the coming together begin and end? Well, those things get kind of fuzzy after the initial proposal. And so while these things are very interesting for us to think about academically and to try to pinpoint them so that we can get a handle on it for ourselves, please, I guess what I'm suggesting is don't get too hung up on these designations and too hung up on any of these things being pristinely clear-cut times, of a negotiation, except for the initial proposal, which of course somebody's got to start. After that it gets kind of fuzzy. So just keep that in mind. And nonetheless, we talk about these things because it's helpful for us as negotiators to sort of think through how we're going to make things work, and it gives us a framework. It gives us some bones to hang the flesh on, if you will. So that's kind of why we're doing this, and it hopefully will make us better negotiators to kind of think these things through and mull through them and analyze them and talk about them and do them. So with that in mind, let's jump on to the discussion of information bargaining. Uh, Gifford kind of puts this ahead of initial proposals, and I guess why I started this lecture with my little admonition to be careful is that in my experience, generally speaking, what happens is, more often than not, is you have an initial proposal and then the information bargaining begins. And so somebody starts the process of negotiation. Somebody says, hey, let's negotiate. Here's an idea. And so they throw out that initial proposal, and then things start going from there. So information bargaining may or may not take place before a proposal gets developed. It's possible. But as often as not, an initial proposal spurs information bargaining. So what does this mean? Well, basically, in a very simple manner, you want to know what the other side knows. What do they know? What do they have? What information do they have that's germane and helpful to you or to your client that will help you get through the negotiation in a way that is beneficial to you or your client, for whoever you are negotiating for. So what are some things you can do in order to gather information? Well, one, I've said this a couple times, I think, and if I haven't, forgive me. This mantra is something that you will hear me say probably several times, and that is, questions unasked are questions unanswered. I like it because it's a simple thing to remember, and as a negotiator, you are going to want to ask questions a lot. You're going to want to ask questions because either you get an answer or you don't get an answer, but even in the not getting an answer, sometimes it tells you something. One of the things that occurs in the practice of law that I've been involved in the most, which is personal injury cases, both on the plaintiff side and the defense side, mostly on the defense side. But one of the things that's often discussed is, particularly in car accident cases, what are the liability limits for the person who has committed the tort? What amount of insurance do they have? And that oftentimes sets the stage for negotiations, because if I have a situation where there's a bad injury and there are very small liability limits, then, well, that makes it a little simpler to negotiate, because probably the insurance company will simply have to pay its liability limits in order to satisfy the demands of its insured, to prevent any kind of judgment that the insured will find impossible to satisfy. So that often becomes a point of discussion. Well, if I'm the plaintiff and I ask the insurance adjuster or the attorney, hey, what are your limits? And there's no answer, that may speak volumes about either their enormously high limits, and I don't want to tell you because then you're going to really want a lot of money, or they're incredibly low limits, and I don't want to tell you because I want to try to get you to take less. So those kind of things come about. How do you find out information like that? Well, you ask. And then you just listen carefully to the answer. I mean, don't ask the question if you're not interested in the answer, unless, and there's always a caveat, unless you don't care what the answer is. I mean, there may be circumstances where you ask a question and you're just asking just to see how the other side responds to the question. So what are some things that you need to look for? Well, one, be careful when people make offhanded comments about things. This may help you to understand where they're coming from. It may give you some sense of the negotiator's ideas about the case. The negotiator may say something that offhandedly, that, gosh, I've got a vacation next week, I really want to get this done, or something like that. Or even less blatant than that, may just say, something about, gosh, my family's going to be really busy, and I really would, just need to work hard. I don't know, something silly that just sort of offhandedly clues you into the idea that this person's got other things going on, whatever it might be. My kid has a basketball tournament next week. Oh, that's interesting. So you don't want to be messing around with this. So maybe I can put some pressure on you to get it done quickly. Keep those things in mind. Don't read too much into those kind of offhanded comments. That's something that would really most likely occur in a face-to-face circumstance or on the telephone. When you're doing negotiations via email, which is predominantly what we'll do in this, that's what we'll do in this course, just because of the constraints of being all over the place. What you'll find is those kind of comments surface less frequently. People are a little more, I think, a little more deliberate in emails, although we'll talk about that as we go along. But even then, people will sometimes give things away like that. And again, it may be a big deal or it may not. It may just be somebody just trying to be nice and just being chatty. So don't read too much into it, but keep it in, sort of put it in your hip pocket. What else? Again, questions, I've already pretty suggested that. Ask why. When somebody gives you a response to something or gives you information that doesn't make sense, you need to ask, well, why? Be a 5-year-old. Why? Why? Why is the world so big, Daddy? I don't know. Well, why don't you know? Well, because I don't know everything. Well, why don't you know everything? Well, because God didn't make me that way, son, and so I don't know everything. I mean, you just think of a 5-year-old and then be one, and just ask why. Pick around the edges, and by that I mean ask unobtrusive questions that somebody's likely to answer. And by that I'm talking about asking things that are easy. If you're negotiating, let's just take something simple. You go to the car lot to buy a car, so let's just make it personal. And you want to ask questions about the car. You don't want the car salesperson giving you a bunch of nonsense. So ask simple questions. Well, how many miles per gallon does this car get? How do I know I can trust what that sticker says about the miles per gallon? Those are simple things. What kind of warranty comes with the vehicle without me buying any extended warranty? Again, that's something simple. It's not a big deal. It's factual information. But it's the kind of things that are easy to talk about. The salesperson knows the answers, and it just allows you to get them involved in the process and answering easy questions. That's what salespeople do to you and me all the time. And if you're a salesperson, please don't take this personally. It's the way sales are done oftentimes, particularly face-to-face personal selling. People like to ask questions. Notice good salespeople often will ask you a lot of simple questions that are easy to answer, and it creates a rapport. It creates an idea that this process will be simple. This process is not hard. This process is something we can get through. Uh, Listen carefully to the other side's questions, because that's going to help you understand where they're coming from and their concerns. Use active listening. I may have mentioned this already. If I have, forgive me, but it's worth repeating. If you're in a face-to-face situation or over the telephone, as best you can over the telephone, it's particularly helpful in face-to-face, use active listening. That means when someone asks you a question, you repeat either the question or the substance of it, and then you say something like, is that what you're asking, or do I understand you correctly? You just rephrase what the person's doing, and you sort of put it in your own terms to make sure that you get what they're talking about. They make a statement, and you say, do I understand that you mean this? That's active listening. It's a good way to try to make sure you're really getting the point from other people, and particularly in face-to-face circumstances, it gives them a sense that you actually care about what they're talking about. It's very helpful. Silence. Most of us are afflicted with the desire to fill silence with something. And you see, if I'm sitting there like that, just looking at you on this video, it's kind of weird. The expectation is that I'll continue to talk because that's what I'm doing. Keep silence in mind. Sometimes it's a good idea just simply to say nothing. Let the other side just keep filling the airwaves, if you will, with their own thoughts and their own talk and their own questions. It's probably rude not to answer questions, but if the other side is talking, just let them talk. I will tell you that years ago as a young attorney, I remember sitting on the telephone with this older attorney, and he just simply didn't say anything. And so we were kind of talking, and then there was a bit of a silence, and he said nothing. And so I just sort of felt prompted to rush in and fill the void and start talking. And I realized after a minute or two that he'd got me to say things that I really probably didn't want to say. It wasn't devastating, but the point is that by simply remaining silent, he goaded me into talking, if you will. That's a very difficult thing to do, but it can be very effective. I've seen in negotiations at Regent, in live negotiations that students have done, I've seen a couple of students actually use this very effectively. It's very difficult to master. You really have to be very good at it in order to master it effectively, but it can be very, very powerful if you can do it. Bait the other side. This is probably a very competitive tactic, baiting them by saying something that is designed to attract their attention in a negative way and get them irritated with you. Be careful about paralinguistic and nonverbal communication. What does that mean? Well, things like eye contact. We'll get to cultural issues later on in the course, but don't assume just because somebody's looking at you in the eye, they're being honest with you. They may or they may not be. Shifty eyes. Some people look down a lot because they're humble, or they look down because they're just shy, and that may or may not necessitate your belief. It may not validate your belief, I should say, that they're doing something wrong or perhaps lying or doing anything like that. Don't assume that. Icy stares. Somebody's kind of just staring you down. Again, some people, that's just their natural way of looking. They just have that cold face. Again, you sort of need to make a judgment call. Are they doing it on purpose, or that's just the way they are? And you'll figure that out soon enough. It won't take long. Body language. Be careful about body language. My personal belief is that it's difficult to really evaluate body language effectively. I tap my leg all the time. That's just a habit I've had since I was a kid. I remember being at a St. Petersburg Cardinals ball game, excuse me, when I was a young man, about 7 years old, and with my dad and my grandpa. They're a farm club for the St. Louis Cardinals, obviously, and I was kicking the bench in front of me and kicking it, and the guy who was sitting on the bench turned around and told my dad, he better stop me from kicking that bench anymore, or he might come over there and do some things to my dad and to me. Fortunately, my grandfather, being quite quite a character, told the guy, hey, shut up and leave him alone. He's just a kid. Uh, and but you might see me shaking my leg during a negotiation, and if you're reading too much into that, you might say, "Oh, he's nervous. I've got him on the ropes." Well, no, you don't. I just shake my leg. It's just normal behavior for me. So be careful about that. It could mean something. It may not. It's worth thinking about. But again, it's something that you can overanalyze. So my attitude about it is sort of ambivalent. I do this sometimes. Just kind of rub my beard. Just I've had a beard for many years, and it's just something I often do. It doesn't mean anything. It's just just one of those habits that sometimes I'll do. It does not mean that I'm necessarily in contemplation. It just may mean that I'm just rubbing my beard absent-mindedly. I do remember a time watching a doctor on cross-examination who literally, as the cross-examination wore on, and he was literally arguing over a comma that he had put in some medical records and suggesting that at the time he wrote it, that comma actually meant something. It was very disingenuous, and it was some of the most disingenuous testimony I've ever seen on the witness stand. He literally was sinking, and I mean literally. He sank down into the witness chair like this as he was testifying, and it became apparent from his body language in that instance something was going on. So it can matter. Remember, when you are thinking about these sorts of things, again, we're talking about information exchange, information bargaining. Just be careful to overanalyze it. Think about it, but always really pay attention to what the other side is really actually saying. All right, I'm going to give you a couple of nevers. And these are rare for me, but I'm going to give them to you just because I think ultimately you're better off getting rid of these expressions from your vocabulary when you're negotiating. One, never say "to be honest" or "honestly," because as soon as you say that, then my ears perk up and I wonder, well, haven't you been honest with me before? I know that's not what people mean when they say "to be honest." They're trying to impress upon the person that, hey, what I'm getting ready to say is just, I'm being straightforward with you. Well, you don't need those kind of expressions. Either you're going to be straightforward with people or you're not. Most of the time when I hear somebody say "to be honest," my indirect inference is I think they're getting ready to lie to me, or they're getting ready to try to say something in a way that's designed to cover up something. I just don't trust it. Get rid of it if you say it. Just get rid of it. It's a worthless thing to say. It provides no value and is probably often detrimental. Just get rid of it. All right? Never say "it's not the money" in negotiations where money is an issue. Of course it's the money. Let's not be stupid about it. If money is involved, then money's involved. That's okay. It's not crass to discuss money if money's part of the deal. If there's no money involved, then I guess you can say it's not the money because there's no money involved. But that's very unusual in what lawyers do. It does happen. I mean, in a criminal negotiation, obviously, if you are a prosecutor or defense attorney and you start talking to someone, it's probably not about the money. But then you don't even need to say it, right? Because it never comes up. In most commercial negotiations and in most even domestic relations where you're dealing with child support and alimony and property settlements, it is about the money. And there's no need to pretend it's not. it's a rare client who really operates just purely on the level of it's just about the principle. I don't really care about the money. Because when they see your bill, they will care about the money. So, if you have a client who says it's not about the money, and then you send them that $28,000 bill, and they say, wait a minute. Well, obviously you'll say, well, you told me it wasn't about the money, right? Just nobody's going to believe you if you say it's not about the money anyway. So don't say that. Just kind of get rid of that as something it's not. So just get rid of that. Off the record discussion. These happen all the time. Attorneys run into each other in various places, especially if you're in a area where the attorneys with whom you interact regularly, or if you're in a business setting where you interact with a group of people on a regular basis. You're going to have those kind of interactions regularly. You can have off-the-record discussions. What do I mean by this? I'm talking about an unofficial talk, and this is especially true with lawyers where you're talking on behalf of a client, where you say to the other side, listen, let's you and I just talk turkey here. I can't do X. I can't give you $50,000 for that case. I can't. I never am going to get there. Give me a realistic number. Tell me something that you think you could probably get your client to do that seems realistic, that maybe you and I can sort of off the record, you and I know we're looking at trying to get to. And I'll work with you to try to get you there as best I can. I'm not making a promise. I'm just simply telling you, if you give me something realistic that I can run with, that lets me go back to my client and say, hey, I think we can get them here. What do you think? And so, for instance, let's say that in a simple automobile accident crash case, the plaintiff's attorney says, I want $50,000. Defense attorney says, look, that's not going to do it. We're never going to pay you $50,000. We'll just go to trial. If you know the other person and you have some level of trust, and usually this is going to require that you've had dealings with them before. It would be rare to have these kind of conversations with someone you don't know, but if you do, you just simply say, look, let's kind of be off the record. You can put it that way, however you want to say it. Let's just be frank. Let's be candid. Can we talk? Can we just sort of talk theoretically or possibly or whatever? And then just say, look, let's be real. What if I get you $20,000? Is that going to settle this case? If we can get in that ballpark or whatever, will that get it done? And then you hope the other side reciprocates. It's a very cooperative type endeavor. And it's very risky in some sense, but it's off the record, and consequently, it's sort of a measure. There's a measure of plausible deniability there. In other words, what you're saying to the other side is, look, you and I are both agreeing this conversation never happened, and or that if it did happen, we're both agreeing that it was done in the spirit of cooperation and not official, and nobody was binding themselves to anything that was said in this conversation. If you have to say all those words, then you probably can't have an off-the-record conversation with the other person that you're dealing with. If you don't have to say those words and they know, then you can. And that's another way to get information. Again, we're talking about gaining information. It's another good way to get information if you can do it. What about concealing information? Let's say there's things you don't want the other side to know. There's skeletons in the closet. What do we do about that? Well, there's a variety of possible techniques you can use to avoid giving information. Tax evasion is illegal. Tax avoidance is legal, right? Isn't that the old saying? Well, information concealment is okay ethically as long as it's done by avoiding, not evading. You can't lie to the other side, okay? If you're an attorney, you can't lie. Let's just make that your rule. Just make that your hard and fast rule. If you are a lawyer, you cannot lie. Just make that your rule and be done with it. The reason is that the ethical rules can be a little gray to some extent. I think the Virginia ethical rule now says that you cannot knowingly conceal information. So it requires some understanding that you are intending to conceal. Other rules may be a little different from state to state. Bottom line is, if you're a lawyer, just don't lie. Okay, find other ways to say things. It's like the old idea, some some elderly woman, if you're a churchgoer, some elderly woman comes to your church and says, "Well, what do you think of my hat?" And you hate it, you think it's crazy, and it's just insane that she would wear that hat out in public anywhere. The answer that I think is truthful and useful and meaningful and avoids hurting anybody's feelings is, it suits you. There you go, right? And if she walks away thinking maybe she thinks you liked it, maybe she doesn't, maybe who cares? You you've been true. You've said it suits her because it does, because obviously it's the kind of hat she likes wearing. Really, all you've said is something that's already true anyway. But you get out of necessarily hurting her feelings by saying it's awful, and you get out of lying by saying, "Oh, it's wonderful." You don't have to say either. So that's the kind of thing you want to do to try to avoid giving away information. What are some things you can do, some practical things? I'm just going to run through a quick list here. Just don't answer the question. I mean, this will sound like what politicians do. Don't answer the question. Shift to some other topic. Sir, what do you think about the economy? Well, I have a 5-point plan for fixing our national defense. Where did that come from? It's not going to talk about the economy. He wants to talk about national defense. And so you just sort of shift the topic. And that's a pretty blatant kind of way to do it. You would probably be a little more subtle, but move over to something you feel more comfortable talking about. Answer a different question. Okay. Again, it's similar to not answering the question, shifting to another topic. Answer the question you want to answer. Give an incomplete answer. Answer part of the question, or answer it part of the way. A practical example of this might be let's say you're negotiating for a landlord, and it's a commercial lease, and the tenant is asking questions about the plumbing. And you, as the landlord, know that you're going to have to do some work on the plumbing. But you're prepared to do it, but you don't want that to scare the tenant away. And so in order to give an incomplete answer, you say, "Well, sure, our plumbing is in working order." Well, that's true, but you want to upgrade it because it needs to be upgraded. Well, you're not lying because your plumbing is working, but it does need an upgrade. So you don't say that because you don't want them to rush out or get worried or, "Oh my goodness, what's that going to mean?" That would be a possible way to give an incomplete answer. You can always say, "Well, I'll answer that if you answer this." The old, you scratch my back, I'll scratch yours kind of idea. Delay. Now, when you're negotiating via email or via voicemail or that sort of, or by letter, heaven forbid, right? We actually write a letter on paper. Oh my goodness. By the way, just as an aside, be very careful about negotiating by text message. I strongly urge you to avoid, Twitter and text messaging as means of negotiating, unless it's simply to confirm something very basic. Just because it's a very limited methodology. Emails are okay, and again, even emails you're going to have to be very careful. We will do email negotiations in this class, and you'll start to see how difficult that can be sometimes. Just so delaying means you just put it off for a little while. Obviously, refuse and tell them why you're refusing. Say, "I can't answer that question," because to do so would result in my client having to tell you some things that just aren't germane to the negotiation, but that it would entail us giving you information that goes beyond the scope of this negotiation. I can't answer that question. Somebody may ask about let's say somebody asks about your client's financial status, and right now there are some question marks about it. However, those question marks about your client's financial status really aren't germane to the particular negotiation for any number of reasons. That might be a time when you just say, "Well, look, I'm not going to get into that. It's not going to affect this negotiation because there's simply those two things don't have anything to do with each other." And you might have to give a little bit of an explanation. Just say a little. Just, somebody asks you a question that's a yes or no. Don't give an explanation. Just say yes or no. Is the plumbing in working order? Yes. Or, yes, it is. Maybe it is okay. Or yes, sir. Or whatever. Yes, ma'am. I mean, whatever. and then leave it alone. Okay. You don't need to explain that you're going to be doing massive upgrades in the near future. Or again, maybe that's a point of like, hey, yeah, we're not only is it the plumbing in working order, but guess what? We're doing massive upgrades, and that's going to make the place 10 times better. You know, again, you have to know who you're dealing with and what. That may be a big issue for a potential tenant. It may not matter. They may not want the inconvenience of plumbing upgrades. It may bother them. All kinds of things factor into why people want what they want. There are some ethical considerations here. Rule 4.1 has to do with being dealing with people in honesty. I mentioned that earlier. If you're an attorney, you basically you have to tell the truth. The book suggests that puffing is allowed under the ethical rules. My personal feeling is this: you stay away from puffing up things as an attorney. A, because then you know you'll never violate the ethical rules. B, the other thing is I'm a Christian, and as a Christian, I want to tell the truth, and I want to be honest with people in my dealings because I ought to be. That's the God-ordained reality of it, is that I ought to tell the truth. And so as an attorney, that puts me in a position of wanting to make sure I tell the truth whenever I'm asked a question. The problem is sometimes the truth is going to hurt your client. The prosecutor asks, did your client have the marijuana in his pocket when he was arrested? Well, if the answer is yes, you might have a problem. And so you have to deal with that. And how do you deal with it? You can't say no because you know it's true. Your client told you, I had the marijuana in my pocket when I was arrested. But for whatever reason, there's some question about it, and you're trying to negotiate a plea agreement with the prosecutor, you're going to have to find a way to deal with that kind of question because you can't just say no. You can't lie. And so what do you do? And again, these variety of methodologies for dealing with that kind of question. You'll pick one and run with it, whichever one suits you and whichever one allows you to avoid without lying. Argument, what about arguments? When I say argument, I'm not talking about arguing as in screaming and yelling. We're talking about a rational, reasoned, sensible discussion or a legal argument that might exist. I'm not talking about appellate argument. I'm talking about basic legal issues. I won't say never on this one, but I'll say be very cautious about making legal arguments with other lawyers. It can be a little insulting sometimes. It's one thing to say, hey, maybe, and this is how I would always do this. Whenever I had a legal issue that I thought the other side maybe wasn't quite kosher about, or they didn't quite understand it, or they didn't seem to be aware of it, normally I'd approach it as, hey, I think this case might apply here. Why don't you take a look at it and let me know what you think? Okay, and so you get the other side thinking that, okay, well, maybe there's something out there. It doesn't come across as, hey, you know what, the case of Smith versus Jones clearly applies in this circumstance. You lose, give me my money. Okay, well, come on. It's unnecessary. It makes you look arrogant. It makes you look presumptuous, and it makes you look like a jerk. And that's not going to be helpful for you or for any of your clients. You don't need to do that. Be conversational as much as possible when you're making legal or even logical and rational arguments. Just lay things out as they appear. If a writing is, whoa, I'm sorry, I'm already jumping into chapter 6. So that gets us through information bargaining. What we've got to do now is get to the chapter 6, which is the initial proposals. What do you do, and who should make the first initial proposal? And forgive me, I'm looking for my notes because I thought I had them right here in front of me. First off, I'll say this. If you are in a position to make a proposal to start the negotiations, then do it. There's no reason why you can't be the first one. I've never understood people insisting that, that the other side had to make the initial proposal and that they had to be the ones to do it. I've never quite understood that. Here we go, chapter 6. Sorry about that. What if you don't know where to start? Well, then you're just going to have to ask questions of the other side. You're going to have to spend as much time as you can gathering information by means other than negotiating. I'm sorry, I'm kind of whipping back and forth here. Who should blink first? You should if it benefits your client. Somebody's got to break the ice. Perfectly fine for you to break the ice if it makes sense. That's really a pragmatic issue. It is not a legal or theoretical or academic issue. It's just simply a practical matter. What makes sense for your client? If it's sensible for your client to be the one to make the first proposal, do it. Don't be pro forma, and by that I mean don't just give some standard nonsense. Don't just kind of lay things out in some pro forma way that the other side's seen before 100 times. Be you may, particularly if you have some kind of high volume legal practice, you may have to use forms, but try to, as best you can, to make things a little more personalized to the situation. And that's what I mean by don't be pro forma. Every demand shouldn't look the same. Every initial proposal shouldn't look identical. Competitive initial proposals, we'll talk about this for a minute in terms of competitive and cooperative. With personal injury cases, for instance, you often find very competitive initial proposals. The plaintiff says, give me $1 million because I got a hangnail on my left pinky and it really bothered me. And it was at least a week that it took for that hangnail to start feeling better, and then another week before it was finally gone. And I just can't stand pain. And I just can't tolerate it. And I yelled at my dog a couple times that week, and my son and my wife just they can hardly stand me. And so I really need $1 million. Well, okay, I don't care how sincerely you say it, I don't care how great it sounds, that's just stupid. So be sensible. Okay. What else? Empirical data does suggest that an extreme first offer often produces a better result, but not that extreme, and that's my point. Basically, high-end offers generally result in better ultimate results. This may be due to a phenomenon, and I forget the technical name for it, I'm sorry. It's sort of like you stake out a particular position and it kind of sets the tone for the negotiation. That may be a reason why you often want to be the first one to get out of the gate in terms of your first proposal, because you kind of put a stake in the ground from which the negotiation then moves forward. And so it kind of sets a tone, if you will. Don't give a range, and this is not a never, but this is darn close to a never in negotiating. If you give someone a range, well, I'll take 10 to 15,000 for that car. Well, guess what? The next offer you're going to get for the car is 15,000 or is 10,000, right? So if you think you want to get 10,000, you're prepared to accept 10,000, but you'll take more, obviously. Start at 15 and see what happens. I'll take 15,000. That's absolutely true that you will take 15,000. See, that's a good way to deal with the question again of ethics. My client will take 15,000 for that car. Well, of course he will, because he'll take 10, so he'll take 15. Use clear-cut language when you're making your initial proposal, so that it's understood exactly what you're offering, particularly in more complicated situations. It's one thing when you have cases where you're just talking about a simple dollars and cents. You're selling a car and you want 10,000 for the car. That's one thing. But if there are going to be multiple issues in the negotiation, or it's going to result in a significant document, a lengthy contract, it's a corporate merger or buyout or something, or anything like that, a commercial lease, or even for that matter, even a residential lease. There's going to be a lot of provisions that get negotiated. Make sure what you're proposing is clear from the get-go. Be ready to justify your proposal in a rational way. Don't be emotional about it. It's important. What about escalating a demand? What if you start off at a point A and you realize I've got to go to point B, which is much higher than point A? Again, this is close to one of those nevers. You only get to do that under very rare circumstances. I will tell you that I remember a case very vividly that I was involved in many years ago where I was defending, and the initial demand from the plaintiff was $40,000 to settle the case. The plaintiff was claiming she had some problems with her shoulder. She had not had any kind of surgery or any kind of intervention in that way, and yet she seemed to have some ongoing problems that seemed to be lingering a bit. But on the whole, the idea was that she was probably going to get better without any further medical intervention. And the plaintiff's attorney said, look, she's been hurting for however long it was. I don't remember that detail, but let's say he said, it's been 2 years. We'll take $40,000. My claims examiner refused. Said no. And I forget what we offered, but it was 35,000 or something. It was a close thing. The plaintiff's attorney was a very good lawyer who I'd dealt with many times, and he pulled me aside. He said, Gus, I don't get this. This demand I'm making isn't stupid. It's not unrealistic. It's not crazy. Why can't you get more money? And I told him, I'm sorry. I've done everything I can. I agree. I told him point blank, I agree with you. And I've told my claims examiner, I agree with you that we should just pay it and be done with it. And in fact, I felt so strongly, I wrote a letter to the claims examiner laying out all the reasons why I thought he was making a big mistake. Well, 3 months later, I get a letter from the attorney saying, guess what? My client is now going to have surgery for, it turns out, a rotator cuff tear. And the going rate for rotator cuff tear surgery cases back at that time in Virginia, when I was practicing in Virginia at that time, was about $80,000 to $90,000. And needless to say, the case ended up settling in the upper 80s, as I recall. We could have gotten it for 40. So here's my point. My point is that that was a time when the escalation of the demand was acceptable because the person's circumstances had changed significantly. So that's about the only time you're going to be able to do that. False demands, I just think you can't do it as a lawyer. I strongly urge you never to make a false demand. That is, never say, my client must have X, whatever X is. I don't care what it is. If that's not true, don't say it. If it's true, then fine. Go ahead and say it. If your client must have X, then say, my client must have X, whatever X is. Otherwise, don't say that. And that would, I'll put that in the never category. Never make a false demand if you're an attorney. If you are not an attorney, you're not obliged legally, obviously, to avoid making false demands. I would say that as a Christian, if you are a Christian, you want to very carefully consider whether you think making false demands is appropriate. I would say not. And you don't need to. I mean, as a practical matter, you can make the demands you need to make in the case without doing that. You can make demands before negotiating and say, look, I need A, B, and C before we begin negotiating, or I'm not going to negotiate. That's pretty risky. That probably is only going to happen when you have a very sophisticated, detailed circumstance in which getting something done before negotiating is appropriate. So I wouldn't recommend doing that. Generally speaking, it's okay once in a while under very sophisticated circumstances where you might have to sort of set out parameters that need to be set out before negotiating. Maybe you have to actually negotiate about how you're going to negotiate, for instance. So that might be okay in those kind of situations. What else? Bulwarism is the last one that I'll talk about. Again, we're talking about competitive initial proposals. Bulwarism is a method used by a number of insurance companies famously over the last several years. I don't know if there's one in particular in the Hampton Roads area that I know used to do this all the time. Here's our offer, $5,428.54. We're never going to change that offer unless you are able to show us some really good reason why we should. Again, it's very risky. It's super uber competitive. Probably not usually a very good idea unless you just feel absolutely confident that that's the best you can do. What about making cooperative first proposals? That is, you come in and you say, well, look, we're willing to work with you. I mean, we understand that maybe you want to do this, this, and this. We understand that let's say it's a commercial lease. To give it some context, the landlord says to the potential tenant, I know you want us to do some build out. We're willing to do some build out for you. In other words, we're willing to make the space a little more useful to you, and we'll pay for that. We're prepared to we're prepared to do that. We're prepared to offer you a discount on the first 6 months of rent. And we're prepared to waive the security fee, the normal security fee of $10,000. Well, you can do that, and then obviously you set the stage for the potential tenant asking for more. So you better be careful. We've discussed this already a little bit, and so I won't pound on it, but as you can tell by my hesitancy, I think most of the time that's not a good idea. It's probably not the best way to start a negotiation. It's a good way to end it. It's a good way to maybe work through the middle of it. It's probably not the best way to start it. What do you do when you get a first proposal? How do you handle it? You can react cooperatively. Okay, sounds good. Let's put some meat on the bones of it. Maybe work through if you have any issues, but otherwise kind of say it sounds generally okay, but here's some things I need. Some models suggest that you should always give an extreme response to the initial proposal. And again, you don't have to do it sarcastically, or you don't have to say that's absurd. You just simply say, no, I can't do that. The landlord says, well, I'm going to give you all these, these concessions that I just mentioned a minute ago. We'll waive the security deposit. We'll do a build out for you. All those sorts of things. And you jump in and say, no, that's not good enough. Not only do I need you to waive the security deposit, you're going to put aside $5,000 just in case you don't live up to your end of the bargain. I mean, it's a reverse security deposit. I mean, maybe you just get obnoxious and ask for something really outrageous. And you're going to give me the first 6 months not discounted but free. That may be the way you actually come out of the gate when somebody gives you a cooperative response. Ironically, that may get your client more in the end. That pretty much wraps up the section on initial proposals. The last thing I'll say, if you're going to get a writing, and by that I mean the negotiation is going to result in some kind of settlement agreement, or it's going to result in a document being prepared, one way to really get things going, and one very effective means of negotiating the process, is to prepare the document in advance with your proposal. So if it's a lease or it's a contract, prepare it. Have one ready and send it to the other side and say, hey, here you go. What do you think? Make some changes, give it back to me, let's see what you got. Again, what that does is it stakes out a position, and that becomes the place from which all further negotiations take place. So it may be a useful means of getting things done. All right, well then we're done for 5 and 6, and we'll be back and talk about 7 and 8 in a couple weeks.